Hi, this is Mike Young, your estate planning and probate attorney in Walnut Creek, California. And I am going to discuss with you how we would typically transfer title of the home of a married couple to their revocable living trust. My website is walnutcreekelderlaw.com, so you can go there if you want more information. And you can feel free to call my office if you have questions at 925-256-0298. So let's say my clients are Mary and Bob Doe, a married couple, and they own a home in Walnut Creek, and they want to transfer their home into their revocable living trust. And they want their trust to state that when both Mary and Bob are dead, that their children, Lisa, Frank, and Jack, will take title to the home. So we create the trust, we make those provisions, those statements in the trust. So now we need to get the home into the trust, and we create a deed. So here is a typical deed. Here's my name in the upper left-hand corner as the attorney for Bob Doe and Mary Doe, 123 Sharp Street, Walnut Creek, California. And here's their sister's parcel number. So here is a typical trust transfer deed. And it says, for no consideration, grantors, Mary Doe and Bob Doe, husband and wife, as community property, grant to Mary Doe and Bob Doe, trustees of the Mary Doe and Bob Doe Revocable Trust dated July 22, 2020, that real property in the city of Walnut Creek, etc., described in Exhibit A. Then Mary Doe and Bob Doe signed the deed, and I notarized their signature, and we have the deed recorded. So now on the record, title is held by Mary Doe and Bob Doe as trustees under their revocable living trust. So whoever is trustee of the revocable living trust has authority to deal with the property and to make transfers. So now Bob and Mary Doe, if they deed the property, will execute it to a third party, will execute the deed, Mary and Bob Doe as trustees under the trust. So the trust says, for instance, if Bob passes away, the home stays in the trust for the benefit of Mary. When both Bob and Mary are dead, the trust says that the property is transferred to their three children, Lisa, Frank, and Jack, in equal shares. So let's say Bob is dead, Mary is dead. Now we want to transfer title, according to the terms of the trust, to the three children. Lisa, who is named as successor trustee after Mary and Bob, steps up and takes bare legal title to the property. So I would create then a document called Affidavit Death of Trustee, confirming Lisa as trustee under the trust. That's recorded. And now Lisa has authority under the terms of the trust to create a deed to grant the property from herself as trustee to Lisa, Frank, and Jack, beneficiaries under the trust. And we do this without going to court. We do this without the bother of a probate court. We control the property through the trust and by the family members. So now Lisa, Frank, and Jack have taken title, and I will prepare a Proposition 58 request that the property not be reassessed, and that Lisa, Frank, and Jack keep Bob and Mary's Proposition 13 value under the property. When we prepared the deed, here's the deed, to the trust. We also prepare a preliminary change of ownership report, which goes with the deed to the recorder, and the recorder shares this information with the assessor. So we have Mary and Bob Doe named at the top, assessor's parcel number, phone number, address. We state that this is the principal residence of my clients, if that's the case. And then we check the box. This is to a revocable trust that may be revoked by the transferor. So that's an exemption against the property being reassessed. So this transfer goes from the couple, Mary and Bob, to themselves as trustees under their revocable living trust. We check this box to confirm the transfer to their revocable living trust, and that is an exemption against the property being reassessed. Then Mary and Bob sign the preliminary change of ownership report as trustees. On the deed, we have recitals that there is no documentary transfer tax, no consideration not pursuant to a sale, a transfer to a revocable trust under this revenue and taxation code. So that confirms the exemption that the property will not be reassessed. There's also another fairly new fee that would be assessed by the recorder if this was not a transfer to an owner-occupied dwelling, but it is a transfer to their dwelling. So we put that recital on the deed, and there are fees, of course, for recording that the recorder charges. So now the property is in the trust as community property, and we want the title to be in community property 99% of the time for a married couple. If the couple held, Mary and Bob held title as joint tenants, I would confirm their tenancy as community property in another deed before this deed was recorded. And I would also prepare a community property agreement where Mary and Bob confirms this property. Here's the address, the assessor's parcel number. We want them to confirm that as community property. And that's a capital gains thing. We want there to be a full step up in basis for capital gains. So let's say Bob dies. We want Mary to now have ownership of the property with the fair market value as of the time Bob passed away, so that Mary could sell the property and there would be no capital gains. So if Mary is the second to die, the property would go to the three children with another step up in basis. And so we want to confirm that by way of confirming the property as community property. And the other thing that we do regarding the real property is have both clients, husband and wife, sign a declaration of intent to remain at home. And this is a MEDI-CAL asset protection thing to make the home, to confirm the home exempt as an asset for qualification for MEDI-CAL. MEDI-CAL wants there to be a subjective intent in writing to return home by the owners. So that's what this document says. It's their residence. They intend to return home as their principal residence, even if they've been in a skilled nursing facility. And in the trust, we have similar language, and we have asset protection language, which now allows us to make transfers of the home if we need to between Bob and Mary and to the children. So this is basically how we make a transfer into a revocable living trust for a married couple, Bob and Mary. So if you have questions, please feel free to call me, 925-256-0298, and take a look at my website, WALNUT CREEK ELDERLAW.com. And thank you for watching this video. If you liked this video, as they say, click below, and you can also subscribe to my YouTube channel. Thank you for watching.